This is a straight matter. Okay, ready? For the record, Your Honor, I will take the burden first. I am talking about Mr. Lexington alone, Your Honor. It is a serious accusation that Mr. Lexington makes against the police department. It is a strange case. It is a very important story about a police force that is concerned about security and its reputation in the community. We have heard the witnesses testify on both sides in this courtroom. The doctor that Mr. Salas alludes to tells you that it is possible that bruises would not be visible. This was a witness called by the prosecution. We are referring to the gentleman that Mr. Salas says supports his position. I submit that the physician that did examine the defendants said that the bruises could be applicable to anybody in any situation and that the source might not be clearly discernible. Now let's move on to the day of the arraignment. What prices or reward would it take an individual who dutifully studies and goes to law school to get up and say that he saw bruises and no bruises existed? Would Mr. Feller get up and tell this court a story of bruises that did not appear at the time? Is there any one iota of evidence to indicate that these injuries, which Mr. Salas may argue about, were self-inflicted? Apparently, they were, insofar as Mr. Lexington was concerned. He was under scrutiny from the minute he reached that station until the very termination of his stay at the Boston Police Department. What more do we have concerning Mr. Lexington? We have the testimony first from Sergeant Zetter and finally from Detective Falk, and that Mr. Lexington was told that Tedford had been beaten. We have testimony from Detective Falk that at the time Tedford says words to this effect, "Hey, Bill, they beat me and hit me." But in the same breath, he tells us that he had not told Zetter about Lexington's confession. He wouldn't go along with this sham, the rouse, the fakery. Let's assume that is a sham and a fake insofar as Lexington is concerned, but that Lexington had confessed. I submit that if for whatever reason they decided, and they testified to it, to tell Lexington and Tedford that Tedford had been beaten, that Tedford makes the statement that he had been beaten. There isn't one bit of evidence to show that anyone said, no, Tedford has not been beaten, but that all the evidence shows that Tedford and Detective Zetter both told him he had been beaten. I submit it would be incredible to say that up to the point Falk had a confession and stood by and let this happen. It would serve no purpose to protect Tedford as the purported snitch. Detective Falk told us that he told Lexington on the second interview that Tedford had already told him everything. Here we have the man in charge of the investigation, Detective Zetter, going ahead voluntarily to tell a man that someone else had been beaten when Falk had already extracted and quite easily a full confession had been given. I can't believe that Detective Falk would allow his direct and immediate superior to make such a fool of himself. I submit that if there was a confession, that Mr. Lexington would say yes to certain statements to put him by Detective Falk, and that it did occur that he had heard about the beating of Tedford. Out of their very mouths, they tell my client in their custody that Tedford had been beaten. This takes place during the third interview, which I believe Your Honor will recall was the one that took place in the evening of the 23rd. The number of interviews that they have had with these people has been testified to, as well as the number of officers involved in interviewing these people has been given. Then we have the coercion for a request to be made that they both be returned back into the custody of Boston to be kept there. I submit, Your Honor, that there is no amount of money that can be paid that would make Mr. Feller get on the stand and say he saw bruises that if he didn't see bruises, because everyone says the bruises got there somehow. There isn't one shred of evidence, one iota of evidence or inference to indicate that someone inflicted the punishment to Lexington himself. We heard the testimony of Mr. Lightfoot, who quickly, and I mean quickly, said yes, Lexington had his shirt off and he saw tattoos. Now, all of a sudden, it becomes Tedford who had the tattoos. It shifts the position where he has turned to the booking procedure and made a case out of that. We have civilian employees concerned with their positions. They work for the police department. They have to get along with the police. While it is a bad charge to make, and I don't think the court has probably heard in the past 10 years a motion concerning confessions extracted by beatings, apparently because police departments have learned that it is only because of motions of this type that they were made aware of the fact that the cases have led to these listed here on Exhibit 22. Okay, I'm going to finish that up. For the record, these cases here listed in Exhibit 22 could be looked at as some type of landmark cases. They set the stage for everything. These cases finally stopped the situations from happening not only in Boston, but around the country in Los Angeles, Seattle, and other cities. And of course, we all know the truth of the matter of the situations. The truth is that sometimes beatings take place in the interrogation rooms of police departments. I submit that it crops up once in a while. You may see it on the news. Police beat suspect to gain confession. It takes a very important case, a case like Toffany, to make it crop up again. Most of the time it is swept under the rug. It was shown that the Boston PD wanted to recover the informational items and wanted to extract confessions so badly that they would revert to almost any tactic. I think Your Honor noticed the demeanor of Detective Zetter. I will let Your Honor draw your own conclusions as to whether or not this man is placid and calm and impossible to rile up, or could be riled up, as he would like to represent himself to everyone to believe when he testified from the stand. I submit, Your Honor, that there were bruises on the body of Lexington the day he went into court. I submit he made the statement as testified to by Detective Falk, among others, and that whatever information was extracted from him when he was kept virtually in constant interrogation was extracted by physical force and coercion and by threats of being pushed down the stairwell or out the window. When Detective Falk first testified in response to cross-examination, he laughed from the stand about this window and about the stairwell. Now, only by pushing and pushing do we discover this. They bring in a picture which shows no bars at all on the windows and no railings on the stairwell. This ridiculous statement that someone would try to push a man through a bar window, and then we discover that Mr. Falk doesn't even know whether there are bars on the window. I find that incredible. I submit on behalf of Mr. Lexington because it is only on his behalf that I argue he was threatened and coerced and frightened, and he was struck, Your Honor. He was scared, and what he told them should be suppressed under the Massachusetts Constitution. They must show what happened beyond a reasonable doubt. They must show that the confession was voluntary. It was not. I submit that, Your Honor. They have not shown that. Beyond a reasonable doubt is the standard in this courtroom. Thank you. First portion was 190. The second portion was 200. Okay, this is a legal straight matter also. Ready? For the record, Ken Mason challenges the constitutionality of the statute with regard to criminal solicitation. He admits that the issue was not raised in the trial court. Where constitutional grounds are raised for the first time on appeal, they are not properly before this court for review. We may consider such issues in exceptional circumstances where the error involves a strictly legal question that would determine the case or where consideration of the new issue is necessary to serve the interest of justice or to prevent a denial of fundamental rights. Mason contends his case is such an exceptional circumstance and should be considered by this court. We disagree. Although the issue is a legal one, his argument is without merit, and the authority he cites is neither relevant nor applicable to this case. We therefore conclude that the constitutionality of the statute is not properly before this court and will not be considered in the appeal. Mason next argues that there was insufficient evidence of intent to support the conviction. When the sufficiency of the evidence is challenged, the standard of review is whether, after review of all the evidence viewed in the light most favorable to the prosecution, the appellate court is convinced that a rational finder of fact could have found the defendant guilty beyond a reasonable doubt. Mason wrote to his friend, "I am asking for help to get bond up to get me out or to take her out. You pick up the one you wish to help me." He contends that this alternative request will not satisfy the intent requirement for the crime of solicitation. He points out that raising bond is not a crime. Therefore, Mason's friend could have complied with the request without engaging in illegal activity. He contends that his offering an alternative is inconsistent with finding that he intended for Smith to kill the former girlfriend. No cases involving alternative requests have come to the court's attention. In one case, the court stated that the specific intent involved was the defendant's intent that the other person commit the crime. The jury found in this case that Mason intended for Smith to commit murder. Simply as a matter of logic, it does not seem that his giving Smith an option should affect that finding because it does not change the fact that he intentionally asked him to commit murder. If Smith had murdered the former girlfriend, he would have been carrying out the act intended by Mason. We find the evidence sufficient to support the conviction. Mason also contends that the letter written by him was improperly admitted into evidence. He sought to have his letter to Smith suppressed on the ground that its seizure violated the First, Fifth, and Sixth Amendment to the Constitution. The trial judge denied the motion to suppress. He noted that an attempt to verify that Smith was an attorney in San Antonio was unsuccessful. He believed that the negative results of that inquiry raised a serious question as to whether the letter was legal mail entitled to particular protection. The facts material to decision on this motion are not in dispute. The question of whether the evidence should have been suppressed is a question of law. This court's review of questions of law is unlimited. Mason's principal contention on appeal seems to be that his letter should not have been opened out of his presence. For this proposition, he cites a number of cases involving real legal mail rather than bogus legal mail. For example, he quotes the following from a former case: "Mail to or from an inmate's attorney and identified as such may not be opened for inspection except in the presence of the prisoner." He asserts that the options available to the jailer were to refuse to send the letter, open it in the presence of the inmate, or require the lawyer to identify himself to officials. He also raises but does not pursue the idea that the jailer should have obtained a search warrant before opening the letter. The United States Supreme Court has approved restrictions on the right of an inmate to send mail. In the famous Martinez case, the court established that prison rules regarding outgoing mail may provide for it to be opened and inspected. The standard to be applied to the search of prisoner mail is the following. First, the regulation or practice must further one or more of the substantial governmental interests of security and order. Second, the limitation must be no greater than is necessary for the protection of the governmental interest involved. Cases involving outgoing mail are divided on the question whether good cause is required for reading it. Another case determined that prisoners' outgoing mail may be screened for information on future criminal activities. In that case, authorities believe that two inmates might use the mail for the purpose of harming prospective witnesses against them. That was at 200. And sometimes 210. Okie dokie. All right, this is a jury charge. Ready? For the record. Members of the jury, any action of this kind is based upon a claim that the defendant has been negligent because the law would not permit you to find a verdict for the plaintiff or to award any damages unless you should conclude first that the accident resulted because of negligence on the part of the defendant, secondly, that there was no negligence by the minor plaintiff which contributed in any way to the accident, and thirdly, that the injuries and the death resulted from the accident itself. Negligence is the failure to use the care and caution which a reasonably prudent person would exercise under the same circumstances. The reason that the plaintiff cannot recover without proving negligence on the part of the defendant is that the law does not raise any presumption just because an accident has occurred that the defendant has been negligent. That is a matter which you would have to find from the testimony. On the other hand, the law holds that if a claim is presented on behalf of anybody, there can be no recovery if that particular person was himself in any degree responsible for the accident. That is what is called contributory negligence. If any negligence on the part of the minor plaintiff contributed to the happening of the accident, there could be no recovery. In this case, inasmuch as the minor plaintiff died as a result of the injuries, the law raises the presumption that he was careful and that he was not contributorily negligent. It would be essential, therefore, for the defendant to prove contributory negligence on the part of the boy. That will be one of the questions you will have to take into consideration. It is your duty to determine the facts. It is your duty to reconcile the testimony as far as you can, bearing in mind the fact that no two persons recount a thing exactly the same. Bear in mind the further fact that there is apt to be little confusion on the part of witnesses inexperienced in court when they get on the witness stand, and consequently minor discrepancies may appear. You take all those factors into consideration and you bring to bear in passing upon the facts your judgment as to who has been telling the truth. In other words, you pass upon the credibility of the witnesses. When you do that, you may take into consideration their interest in the outcome of the case, if any. I do not mean that just because a person may be interested in the outcome of a case that he or she is not telling the truth, because obviously in many, many instances they do tell the truth. That is merely a factor for you to consider. You bring to bear all those qualities that you have acquired as adult human beings, which enable you to determine whether a person is being truthful or untruthful. Although I shall refer to the facts, you take your recollection at all times in preference to anything I may say. It may be that I will make some error inadvertently in discussing the facts, or I may overlook something that you think is important. So you trust your own recollection. It is also your duty to determine what inferences flow from the facts that you think are established by the weight of the credible evidence. Your verdict must be unanimous. You take your instructions as to the law from me, but you are the proper persons to determine just what happened in this particular case. You must arrive at your verdict without either prejudice or sympathy. You have absolutely no right to find a verdict against any defendant because you sympathize with the plaintiff. You would have no right to find any verdict because of prejudice or any feeling of that kind. You are, as briefly as I may put it, an impartial fact-finding body, and you approach your duties in an entirely dispassionate frame of mind. The first question for you to determine is how this accident happened and where the responsibility lies. I may say to you that the duty upon the part of the automobile driver is to handle their vehicles at all time with proper care under the circumstances. For example, when a motorist comes to a street crossing, he is not free to drive quite as rapidly or quite as freely as he might drive in between streets. He must take into consideration the fact that he is coming up to a crossing. Also, if a motorist is going to make a left turn on a street where there is two-way traffic, it is obvious that before making the left turn, he must exercise special care to see that there is no traffic coming in the opposite direction before he is at liberty to pull across the other traffic lane. Are you warm enough, or do you want me to do another jury charge? Jury charge? Another jury charge, okay. Okay. Jury charge. For the record. Ladies and gentlemen of the jury, this defendant, Herbert Powers, is charged by an indictment returned by the grand jury of this county. One count charges burglary of a dwelling in the nighttime, which is a capital offense. The other count charges grand larceny of a home from a dwelling house. However, only one count will be submitted to you for your consideration, and that is the count charging that he broke into and entered the home of Michael Durant in the nighttime. You can't convict him under both counts. You can only convict him under one count, and that is the count that will be submitted to you for your consideration. Under our system of laws, the defendant is presumed to be innocent. Every defendant that is brought into court before the bar of justice in answer for criminal transgressions is presumed under our fundamental law to be innocent, and that casts the burden upon the state to prove him guilty by the testimony beyond a reasonable doubt and to a moral certainty. Now, you have heard the testimony. You saw the witnesses as they gave their testimony. You had an opportunity to observe their demeanor upon the witness stand, any show of nervousness or lack of it, any hesitation. Did any of them pause and hesitate while giving their answers, or did they speak out forthrightly? The law says that you may even take into consideration the facial expression of the witness as he gives the testimony in determining what weight and credibility you will accord to him. All the circumstances surrounding the witness in the giving of his testimony, the manner of the witness, the demeanor of the witness, everything is to be considered and weighed by you in determining what probative value and force you will accord to his testimony. Now, the defendant elected to become a witness for himself and testify in this case, which he had a right to do, and you cannot capriciously cast aside his testimony. The law says that you must take his testimony and consider it along with all the testimony in the case, but that you have a right to take into consideration the fact that he is the defendant and is interested in the result of this trial. There was some evidence in this case that he was previously convicted and served a term in the penitentiary for a crime involving moral turpitude. You may consider that for one purpose only. It goes to his credibility. You may consider the testimony in determining what weight you will accord his testimony, how much credit you will accord to him as he testified in the case. You are the sole judges of the facts in this case. It is your responsibility to resolve the facts and determine what the truth is. As I said, the burden of proof is upon the state to convince you beyond a reasonable doubt. Then that calls for this question: what does it take to constitute reasonable doubt? It is not an imaginary doubt. It is not a speculative doubt. It is not a fanciful doubt. But the law says a reasonable doubt is an actual substantial doubt, a doubt for which you can give a reason. It must be a reasonably substantial doubt. The state doesn't assume the burden of showing beyond all possible doubt. Everything relating to human affairs or pertaining to human transactions is susceptible of some doubt. Our Supreme Court has ruled, and the law writers have tried to hit upon a reasonable, fair, and sensible definition of a reasonable doubt. They say it is actual and substantial doubt. Now, if the testimony in this case is such as to create in your mind a bona fide conviction of the guilt of this defendant, then you are convinced beyond all reasonable doubt, and you ought to convict him. On the other hand, if you are not so convinced, it will be your duty to acquit the defendant. As I said before, you are the seekers after the truth, and it is for you to find the truth. And when you find it, write it into your verdict and let it speak out. Truth is a fundamental virtue. Banish it from the earth, and you might as well banish the light, because the world would be a desert. That got up to 220.